Hi everyone, and welcome back to the Property Podcast Today show. I'm your host Lee Dahill, and today we have Sean Hooker, who's the head of the Property Redress Scheme, on the show. We're going to be talking about market landscape, Renters' Rights Act, and how landlords compare. So the first part is on the market landscape, and my very first question for you, Sean, is what are the key trends shaping the UK rental market as we head into 2026?
Right. Okay. So yeah, the trends for this year. That's $1 million question. So what we know is it's going to be a year of change, but then every year is a year of change. So what are the things am I seeing? Well, I'm seeing that the confidence is relatively okay. I think that's one thing that people were fearing, that people were getting very disillusioned and panicking in the market. I'm not getting that impression from the people I'm talking to. There's a resilience out there, and there's a determination for those landlords that want to stay in the market that they are going to make this work. So the trend is about kind of having a very close look at their market, at their portfolio, and there are people investing. But those people investing are doing it with different strategies than they may have done in the past. When I mean different strategies, I mean they're thinking it through a lot clearer. So it's not a matter of, oh, I fancy that property, I see that at an auction, I'm going to buy that, and then and see what happens. I think they're going in with a little bit more kind of circumspect and research, and those ones that are doing that are still finding good value in the market.
I think that's very fair perspective of the market. And I want to ask you around the interest rates and how do you see them impacting landlords and tenants and the cost of living?
Well, look, I think we've got over the worst of the interest rates fluctuations and the rises. I think a lot of people fixed their mortgages as when they had the opportunity to do that, and I think that they're getting used to the new normal now in the lending market. And the products seem to be coming back onto the market. I'm not a great expert on mortgages, so don't take my word for it. But from what I can see and the people I know in the industry, is that there is more value out there. There's more products. The lenders are being more facilitating in terms of lending. So I think from interest rates point of view, that's not a primary threat to the market this year, I would say. And in fact, it may well improve. In terms of cost of living, absolutely, that's hitting everybody. And there's two things where that's hitting. Is number one is on costs to landlords, which are going up. There's no two ways about it. We have a relative skills shortage in this country. Everything from raw materials is costing more, and it's a trader's market at the moment. So I think landlords are finding that things are more expensive than they have been. That's putting their prices up. The only way they can recover those costs is through rent rises. However, it's also hitting the tenants, and
Yes.
we know that a lot of tenants are reaching peak affordability at the moment, and therefore they really cannot afford to pay the rents that in some parts of the country. So we will be seeing this kind of standoff between the fact that you will need to recover your costs because things are more expensive. You try to put rents up, and the market not really tolerating that. What that will mean, however, is counter to the way that some landlords might be thinking, is actually this is the time to invest in property, because if you are bringing your properties up to a higher quality, then you are going to actually be able to attract the higher rents than your competitors. So it's that kind of like getting your head around and saying, actually, yeah, if I can get my property to a grade higher than the one next door, I will be able to get the higher rents. But you've got to do your homework and balance out your cash flow versus your income plus everything else.
Yep.
You now need to kind of be absolutely on top of every single one of your matrices and figures.
You do. And on the kind of leads on nicely onto the sort of supply crisis, do you foresee improvements, or do you think it will continue to challenge the market?
I think we always have in this country. We will always have a supply issue. I think the issue we've got now is depending on what sort of area you're going into the market on, there's going to be different pressures on you. So, for example, we know there is a relative shortage of student accommodation, and some of the changes that are going to happen in the due to the Renters' Rights Act is going to impact that. So there'll be high demand there, but maybe low supply, because trying to get the right type of properties that will suit the student market is fairly tricky. We know that the strategy for a lot of people have been to move into HMOs. There's a lot of really sensible reasons for doing that. Co-living can be a very effective way, especially for younger people, for them to afford and to live in areas that maybe they wouldn't be able to afford if they were living on their own. However, we know that councils are targeting HMOs as an issue for antisocial behaviour, for revenue raising, for licensing, all of these things there. So some of the areas that may have been productive for going into the HMO market now may be more hostile because of licensing or Article 4, planning permissions and other stuff like that. So again, research is absolutely essential. But the government is building more houses. They won't reach their targets. No government ever reaches their targets. They set a target and then they fudge them. But there is activity. We can see all around this activity, and they're trying to amend the planning laws to make it slightly easier, etc., etc. But again, high demand means that you can command higher rents, but it also means that supply will be low. So picking your areas right is also essential for a landlord in terms of where they're going to actually invest their hard-earned cash.
So that's very fair. And Sean, at the start I said about market landscape, Renters' Right Act, and how can landlords prepare. So the second phase of my questions are on the Renters' Right Act.
Yeah.
So when does the Renters' Right Act officially start impacting landlords?
Right. So the answer to that is it has already.
Yeah.
So, for example,
It was a bit of a loaded question, to be fair.
Yeah, it's a bit of a loaded question. So, look, after all the waiting that we were, waiting for this to be enacted, going through all the parliamentary processes, that uncertainty, it relatively ended when the Act was passed. However, we are on an implementation pathway. The first big milestone was that the local authorities got their extended powers at the end of December, 27th of December. They inherited all these new powers under the Act, so higher fines, more investigative powers. But of course, they're going to take time to gear up. They've got to train their staff. They've got to gear up everything on that. And of course, some of the things that they will be asked to enforce haven't actually come into place. Now, look, what I'm going to say two things. Number one, okay, is that you have still got to do your own research on this and make sure that you are fully up to speed with all the nuances of this Act. But I'll run through roughly how the Act is going to be implemented. As you say, there's going to be a phase 1 and a phase 2. So what does that actually mean? Where are we sitting at the moment? So we're sitting at the moment on the fact that the government have issued a statement that needs to be issued by all landlords to their tenants to inform them of the changes, and that has been drafted literally today. But let's go through very slowly what will be coming in on this magic day, May the 1st, 2026. Should be a massive big red circle on your calendar. And you should be aiming of that D-Day date. It's such an important date for you to be geared up on that. Now, listen, you guys that are listening to this podcast, you've got an advantage because you are literally aware of what's going to be happening. I think there are thousands of landlords out there that haven't got Scooby-Doo at all about this. They may have an inkling that something's going to happen. They're not entirely sure. They've got other fish to fry at the moment. Everybody does, and they're going to just not realise that there are critical dates now that you need to understand understand to protect yourself ongoing in the light of this Act. So let's see what we're going to do. So abolition of Section 21, no fault evictions, they will be banned, and all assured short-hold tenancies will transition to a periodic rolling tenancy. Now, we are familiar with rolling tenancies. It's what a lot of landlords do at the end of a fixed term. They let it roll onto a periodic. There is a notice period by both parties, and that's how it all works. But from now on, there will be no fixed term. You will not be able to say to Lee, I'm going to give you a 12-month tenancy, happy days. At the end of the 12 months, we will part ways. These tenancies will roll on in perpetuum until one party gives the legitimate notice to quit. We know that the terms, the notice, you cannot now not give a reason for giving a notice period. So the no fault evictions, which were never no fault, they were used as a way of saying, literally, let's just get a tenant who may not be paying the rent, maybe a bit of antisocial behaviour, or may just want to move on out of the property without too much fuss relative to the other Section 8 grounds that were there and have always been there. So those grounds, there will have to be a ground 8 type reason to leave, but the ground 8s have been extended. The main ones that everybody is mainly concerned about is if I want to sell the property or if I want to move a relative or me back into the property, I need to have a mechanism to do that. Of course, then there's all the arrears and antisocial behaviour and various other things, renovation to property. Do your homework on your Section 8s when when you need them. Be familiar with them because you're going to need them ongoing. So that's Section 21, the abolition. That was that's the kind of the key change. It was the one that motivated for 5 years the changes, and now the government will be able to say at whatever elections they're going to stand, we abolished Section 21. We also know that they have tinkered and they have changed the way that you can now increase rents. Now, in the past, you would put in your tenancy agreement, a clause possibly that, telling the tenant how you're going to increase rent. You could probably even do it on an informal basis. But there was always this thing called Section 13, which was an official notice to change the rent. They have now made that the only way you can actually change the rent. You can only do it once a year, and you can only and you have to give notice to the tenant that you're doing it, and you have to inform the tenant that they've got the right to appeal it, and they can appeal it through the tribunal. If it goes through a tribunal, the judge at the tribunal can only decrease or agree with the rent increase, or decrease it. They cannot say, well, actually, the market rate says that you can charge more. They could have done that in the past, so they are limited only to what you ask as or lower. And in the time that the hearing is there, you cannot charge the higher rent, and you cannot backdate that rent once it's been granted. So you have to get into that situation of understanding that rent increases are not going to be straightforward. Now, between you and me, Lee, one of the things that was a weakness of a lot of landlords is they were quite reluctant to increase rents anyway. They would do it periodically. They would do it, as and when, right? Rather, or mainly when they changed tenancies and they reviewed their rents there. What they should have probably been doing is, having a disciplined, systematic annual review of the rent, conversation with their tenants and changing that rent. So there was an expectation, just as everybody expects, when you subscribe to something, or your mobile phone, or your Sky television, every year they'll send you a little letter saying your installments will be going up X or Y. Of course, when the interest rate crisis hit, everybody suddenly realised they weren't making money, and they tried to increase their rents by quite substantial amounts to recover that money. The shock of that, even though the tenant was probably enjoying maybe a lower than market rent, the shock of that has caused ructions within the economy, and the government now has taken that into account, and over the course of the renters' rights bill going through Parliament, this is where the rent kind of clauses came in, and the government sort of identified this as an issue. So now ongoing, you will now have to have a disciplined way of actually increasing rents, and make sure that you're engaging with your tenants as early as possible, because you can't kind of agree anything outside of serving that, but you can warn them that that rents will be going up. You can't say, I'm going to put your rent up. You need to serve that section 13, but you don't want that arriving on their doorstep as a big surprise to them, and then they find that they've got the right to go to a tribunal and appeal. And believe you me, there will be people out there acting out of the best of interest. For who, I don't know, but we'll be going around to tenants and say, did you know you can contest your rent increases, and take them to the tribunal? And we will find that some tenants will do that, some will not, especially if you've got a good relationship. But don't take any chances. Make sure that you've lined up all your ducks and you're doing this process absolutely to the letter. Government also identified another phenomena during the passage of the bill through there, that apparently in certain parts of the country, and actually, yeah, I have seen some evidence of this, but it's not widespread across the whole country, of where there's very, very high demand, a lot of tenants chasing very few properties, that the tenants have been encouraged into the highest bidder wins. And therefore, queuing up there and saying, well, I'll offer £100 more a month than X or Y. Now, they can still do that, and nobody's stopping anybody going in and paying more than what the asking price is. But what you cannot do is, you cannot, as an agent or a landlord, encourage or set up a bidding process or something like that. You can't hold your own little separate auction. You have to be detached from that. Okay, the asking price is the asking price. If after that, if after that you can, you've accepted a tenant on that basis, you negotiate a higher price, that's another matter. But these bidding wars will stop, and it will, it will affect those landlords in high, very hot kind of demand areas. And to be fair, I don't think the rest of us will lose any sleep over that. For the rest of us, I don't think it's going to be much of an issue, but it will mean, whenever you are advertising, is get your pricing right. Okay, remember, number one, that if that's the asking price, that's the asking price. But number two, that it can be contested. So don't go in there with silly asking prices. But maybe put one up there, and then you've got the flexibility of negotiating down if you feel that the demand isn't as high as at that price. You could always go down, but what you can't do is necessarily go up in the same way that you may have done in the past. Pets and discrimination. There was already a lot of discrimination law. We should not have ever been kind of prejudicing people just on the basis of non-financial factors that don't affect the affordability of the property. However, these are now being strengthened, and there will also be caps on what you can take as rent in advance. And so therefore the days of taking 6 months rent in advance have gone. You can only now take, I think it's a month in advance, and that means that you're not asking for huge amounts of upfront money. It will mean you having to do a little bit more homework on your tenants. It will mean absolutely doing the highest quality of referencing that you can possibly do, and also using guarantors and guarantor funds as prudently as you can to protect your interests. And of course, we've had the enforcement coming in. So that's the very detailed phase one in May. The rest of it, phase two, that's when the private rental database is going to come in. They're looking at getting that in place by the end of 2026. It's not going to be a sophisticated portal from what I can see, but it will be a start, and I believe it will be something that will evolve over the years. No idea of cost, no idea of what is entailed of doing that. As soon as we know that, we can let you know that. But that's aimed to come out by the end of 26, along with introducing then after that the landlord ombudsman, and that will be the equivalent of what the letting agents and the estate agents have with myself and the TPO, but this will be dedicated specifically to landlords. It will be separate from the letting agent one. It will work very closely with them. The rumours at the moment, or not the rumours, but the intention at the moment is to merge the housing ombudsman from the social sector with the housing ombudsman that they're creating. There are pros and cons on that. Watch this space, but that is phased for 26, 2027. Okay, and then of course we then have the, the the decent home standards and AWAB's law, which are to do with the quality of property. I was looking at that, and it could be as late as 2030 that they start even looking at implementing that. So we are looking at a 4 to 5 year program to get everything that's in the Act into the market. So we're on another big long journey. So it's a lot of kind of homework and research and change that you're going to have to adapt yourself. On top of that, of course, we've got the EPC changes, and we've got other things that will come in terms of taxation and everything else. It's a challenging time to be a landlord, but the information is out there. It just means you've got to gear up your business to adapt to those changes. That was a lot of information in as quick as I could put it through.
It was. You've answered an awful lot of the questions I had within this. I've just got one clarification, which from all of this. You said about the AST, assured short hold tenancy, being monthly rolling afterwards, essentially. Is that from the start that it will be monthly rolling, or is it that you still do, say, for example, your 6 or 12 months and then it's monthly rolling, or is it monthly rolling from the start?
From day one. From day one.
Monthly rolling from day one.
Yeah, and that's the thing. That was just talk about having kind of bedding in periods and stuff like that. But no, essentially that's one of the things that may be a challenge. I'm not saying that there was huge numbers of people that would, literally say, well, actually, I need an accommodation for 3 months. I'll just go in and as soon as I move and give them 2 months, notice. But the government's argument for that was basically, what happens if you move into a property and there's issues with it, that maybe I wasn't disclosed, and I'm now trapped in a contract that I can't walk out of. Now, my argument of that would be, well, yeah, you could always, if someone misrepresents a property, doesn't give you what you've paid for, you can attempt to unwind that contract, but it's never as simple as that. So now the fact of the matter is, you move in rather than getting a big row about the landlord promised this and didn't deliver. You just basically give them the 2 months and you're out and you're free as a tenant.
That's from May 26th.
Yeah, correct. Yeah.
From May 26th, actually. I just wanted to clarify that one part. And then my final question for you on this is on how do you see the court reforms impact on the timeline from abolishing the Section 21?
Well, you're right. I mean, it's like everything else, systematically over the last decade, we have cut costs within our justice system. Courts have closed, costs have been cut, and the demand has gone up on it. So we know that courts do have backlogs, they do have strains. The government has said there is a digitalisation programme that they are undertaking, and they are confident that the benefits of that will be seen. We've all been here. We've all undertaken digital transformations, and we've all known that they haven't ever been completed on time or on budget. So we know that the government has a challenge. A big question I have got is that, will this necessarily mean more use of the court? The answer to that is yes, but would it be absolutely everything has to go through the court? And the answer to that is no. I still think there is scope for, as in the past when you served these notices, everybody amicably deciding that this is what they want to do and move on. Not involving the court, not involving anybody else. I still think a good number of transactions will be ended that way. And George always better than war. But those cases where you do have to take court action, I think you have to gear yourself up for a longer period of of waiting for that property to get back. So I think, if you're going to be somebody that literally say it's got placement in, say you get a placement to open a media center in Holland because your bosses want to expand into the Dutch market, and they say, well, you and the family got to move out for a year, and you say, well, I'm going to rent my property out for a year, but after that year I'm coming back, I want my property back. You're going to have to make sure that the tenants you've got in there totally understand that's the deal, and that if they fall in love with the property and they want a property for a longer term, it ain't going to be your property. You need to get that on understood. You've also got to understand that if you get tenants who are in arrears, it's going to be more difficult to get them out. They say it's going to be easier to get them out for antisocial behaviour. On paper, there were, the burden of proof is going down, and it will possibly be better, judges will be more amenable to looking at the evidence, but it's very difficult to in those cases to really get the tenant out for antisocial behaviour, because especially if it's an internally, say it's the antisocial behaviour is not affecting the neighbours, it's affecting the people within an HMO, for example, and trying to get people to give evidence to explain everything to everybody, that's going to be a bit more challenging. So therefore, whenever you are approaching an eviction that's going to need the court, you need to line your ducks up absolutely spot on, so that you give the judge no excuse to defer a case or to delay a case, because you're going to be in a queue anyway. You've got to have to be the fittest person in that queue to get yourself through. So I would be seriously making sure that prevention is always better than cure. Make sure you do your referencing, your checks, your conversations, your understandings. But we know things change. Make sure that you act as quickly as possible. You look for you look to mediate before, so because at some stage it might be people's mutual interest to leave a property without having to go through a court. If you can do that would be brilliant. Nobody wants to sit there and get themselves purposely into debt if there is another option. So all of those things you can do, but it means that you've got to be on the ball. And you've also got to line up your allies, and that is to make sure that you take out the right policy covers, such as rent guarantee insurance, that you make sure that you use professional regulated eviction companies to do your services and your eviction work, because you're only one mistake from a massive delay and a huge financial loss. You make sure that all your paperwork is up to date, that your communication with your tenants is as best as you can possibly have. Build that relationship up so it is very, very tight, and that that you are on the ball on everything. If you cannot hand on heart say that you've got the capacity or whatever to do that, maybe your full-time work or your properties are in a different part of the country, get a first-class agent. We do have a challenge in this country that unfortunately the regulation of agents is not as robust as it should be. It is something the government is looking at. It's something on the agenda. It's another change. Agents out there who are listening, you will be faced with exams and codes and other stuff in the near future. But for the landlord, when they're looking at managing their risk and managing their properties, invest in a good agent, but make sure that you do the due diligence on that agent and that they do what it says on the tin. Yeah, I would be, I'm advising agents now, if they are going to engage in a lot of this this change, especially in the VIX and stuff there, make sure that they've got all their ducks lined up. They're not solicitors. So, a lot of them would maybe turn around and say, actually, we can't do that. It's too risky for us, because if it goes wrong, the consequences on the landlord is they can sue us and get money. So there is a scope out there now to find the right experts, the right people to do and skills that are needed to deliver this. And it will separate the sheep from the goats, I'm afraid.
It will indeed. And I think you've covered a lot there, because that was what I was going to move on to about preparing. You've covered a lot there about what agents should be doing with the new rules coming in, and the would you say, for updating the tenancy agreements to stay compliant, would you say using an agent would help with that, or is there a way a landlord could do it themselves? How do you see that?
Right. So I think the two things, if we slightly just, get the understanding of a landlord using an agent. Number one thing that will change from, a pretty PDQ, if you're not already aware of it from your agent, the way that agents will be charging will change because of the way the tenancies will be run now. There won't be renewal fees. There won't, we don't, the annual fee, you can't say, well, actually, we'll take an annual fee and then we'll apportion it over the 12 months, because you don't have the tenancies go to last 12 months.
Yes.
You will get monthly fees. You may have to pay, get deferred upfront fees. There may be, if tenants leave early, there may be that you pay back fees. I don't know. All the different agents are all exploring the way that they're charging, right?
Yes.
Number two, then, if an agent takes on some of these obligations to manage your transition, say for example, if they take a responsibility to send out if they take out the responsibility to send out the statement, for example, and the information that tenants need on that, they've got to make sure that they're protected, because so number one, they need an agreement with you to do that. So you're going to have to delegate them the power to do that. They can't just do it on your behalf. That you'll need to have an arrangement there. They may charge you for it, they may not. It depends on the agent, but you need to have that understanding, and they need to understand that if it goes, you need to know what happens if it goes wrong and who's responsible, because ultimately you are responsible, and you will get the £7,000 fine if you haven't sent out the appropriate document by the end of July. You will be the one that will get fined if you don't, if you break one of these rules. If there isn't a robust relationship between you and the agent, you'll be coming to me to complain about the agent. You'll be going and trying to, to your lawyers and saying, well, I wouldn't have done that. I wouldn't, I told them to do it. Now the judge won't buy that, but in terms of, when he's dishing out a fine, but in a civil case, you may be able to take an agent to court for promising to do something and then not delivering it. But if you haven't got that written down, if you haven't got the arrangement from both sides, we're looking at some agents and some landlords getting themselves in a bit of a fix. My advice would be for landlords and agents is that if have that conversation. If it's something that both of you feel that you need expert advice, go and find a specialist. A company with that's regulated, and get lawyers to do it for you, because they will protect your interests. That investment could save you tens of thousands of pounds in the future, because if you've got, can you imagine if you've got 15 properties and you do them all wrong, and it's a £7,000 fine for each one of those?
Yes.
Even 5 properties, 4 properties.
Yep. Exactly.
You can't afford to get it wrong.
No, and obviously you've got the likes of our channel, your channel, yourself. But what tools or resources do you think landlords should be using to stay informed about the changes?
Right, so absolutely, go to your trusted sources. So the trusted sources, are the media outlets that you've mentioned ourselves and Landlord Zone, and yourself in Letting Agent Today and Landlord Today. Negotiators Good. There's several of them. If they're the well-used ones, then the information that they will be providing will be fairly robust. If your agents are members of Ucala or Property Mark, a lot of information is coming from them. If you haven't treated yourself to a birthday present this year for about 100 quid, join the NRLA. They have a lot of information. Plus, they have a helpline, and they also, they also will give you discounts on things like insurances and other stuff there. Make sure that that you have the right covers, okay? And you don't have to pay through the nose for these. So, for example, one of the things that will happen in the future will be there's restrictions on you blanket refusing to take pets. You can't have a no pet policy. But I know a lot of landlords, and rightly or wrongly, they perceive that pets are a higher risk. There is a risk from having pets, but there is a risk from letting to with children, but you can't prejudice against them. So there will be insurance policies that will go out there that will help to mitigate that. The government were going to make it that the tenant would be able to pay for that, but they withdrew that. That was another thing that they thought the tenant shouldn't pay for anything. You've got to pay for everything. But sometimes paying for something to protect yourself makes sense. So make sure that you do your homework and get the right covers in place, and they're proportional to your business. There will be people out there that will try oversell you cover. Don't go down that path. Just make sure that you say, well, actually, this is what I want, and then get the product that actually suits your portfolio. If you've got 15 properties, you're going to need to pay for more cover than if you've got 2 properties. There's no two ways about it. And and that's got to be factored into your expenses over that. And and these are now got to say, well, actually, it's always hard. January's always hard. It's like I get all these bills. Everyone gets the bills after Christmas. We've all spent a load of money of Christmas, and then suddenly all the bills of subscriptions come rolling in, and you're going to go, oh my god, I've got to pay this, got to pay that. All seems to come at the same time. So you've got the opportunity now, and there's taxes going digital for a lot of people, landlords day. So you can now say, well, actually, let's all pile it into the beginning of the year. Let's just put it over the year, and let me distribute my costs across that year. But these are my costs that are coming through. And there's a lot of software out there that does it now. Back in the day when everyone had a ledger and then the revolution was a spreadsheet, and then that was great until Excel kind of crashed and you couldn't, and you had to kind of like reconstitute it. But now the software out there that is on display, it's amazing. It's all done on the phone.
Amazing, buddy. It's amazing. And my final conclusion for you, because I know I've asked you a lot of questions that are hard to answer and take a while to answer because of the fact that there is so much information that's changing right now. And I'm really pleased that you've gone through it in such level of detail so people can understand it. But my final question is, if you could give landlords one piece of advice for navigating these changes, what would it be?
Realize you don't know it all. Ask the right questions. Then question the questions. Research them. Verify them. And do the process all over again. Some of you might be screaming at me. I might have said something in this last 20 minutes, half an hour. And some are screaming and say, no, that's not right. That's not right. Okay. We also know that the government might not even get this all right first time around, and there will be legal challenges. So keep on, on board. And secondly, don't try and cheat the system. Mm-hmm. There's been 5 odd years, of heated debate on this. Many legal eyes, many experts' eyes have gone across there. They may have missed stuff there, but you're not going to be the one there that has found the only thing that's going to stop, the little loophole that's going to only you have found. They have looked at that, and even if there was that loophole and you manage to find it, they will close it quicker than they'll close it as quick as possible. And you don't want to be a test case. You don't want to be sitting there in front of a tribunal or a judge and then appear on the front page of Letting Agent Today or Landlord Today, landlord banned for 5 years, record fine for landlords.
You don't want to be that guy.
You
You
don't
don't
want
want
to
to be
be
that
that
person.
no,
You don't want to be
wanna
him or her.
that person.
You don't
Yeah,
want to.
yeah. Or you don't want to be, you want as an agent, you don't want to come to me as an ombudsman. We're here to help, but and we're the kind of the easy option compared to court because we try and resolve things privately. And hopefully the new ombudsman for landlords will do the same thing. It will be some carrots as well as sticks. But even that, means that you've got to go through a process that you could avoid. So prevention is always better than cure, and it always is important to make sure that that you are on top of it. So as I say, do ask the right questions and do make sure that the information that you are getting is verified and confirmed. And don't be afraid to invest in your business and your knowledge. So okay, fine. It's great if you're on a forum on a website, and Joe Schmo who's been doing this for 40 years, gives you a bit of a tip, and then you find out that Joe Schmo doesn't know his, you know, from his elbow, and you're the test case,
Yeah, that's
and you go
exactly
down
it.
to him and say, well, you told me that. Well, says, well, I'm not a solicitor. You didn't pay me for that information,
Yeah,
So
very true, buddy.
line your ducks up.
Sean, thank you so very much for all your knowledge and coming on the show and spending the time. I really appreciate it. And thanks to the listeners to listening.